Welcome to the Law Student Digital Notes, Criminal Law 1, Part 1, a digital note and reviewer of a JD student. This Law Student Digital Note Reviewer is intended only for the review and recall of topics and contents covered in Criminal Law 1. The maker of the video does not claim the ownership of the commentaries used in this reviewer. The rights belong to the respective authors and are properly cited during the making of this digital reviewer. No copyright infringement is intended by the maker of this video. This digital reviewer is made using and by referencing to the book The Revised Penal Code, Criminal Law, Book 1, Articles 1 to 113, written by Professor Luis B. Reyes. The maker of this video strongly recommends to all law students to buy the said reference material as it will augment their continuous desire to study the subject matter in in-depth perspective. The part 1 will cover the definition of criminal law, the definition of crime, the sources of Philippine criminal law, the concept of common law crime, the power to define and punish crimes, the limitations on the power of the law-making body to enact penal legislation. Definition of criminal law. Criminal law is that branch or division of law which defines crimes, treats of their nature, and provides for their punishment. The sources of Philippine criminal law are the Revised Penal Code or Act number 3815 and its amendments. 2. The special penal laws passed by the Philippine Commission, Philippine Assembly, Philippine Legislature, the National Assembly, the Congress of the Philippines, and the Batasang Pambansa. And third, penal presidential decrees issued during the martial law. Crime is an act committed or omitted in violation of a public law forbidding or commanding it. Common law crimes as the body of principles, usages, and rules of action, which do not rest for their authority upon any express and positive declaration of the will of the legislature, are not recognized in the Philippines. Common law crimes are known in the United States and England. Unless there be a particular provision in the Penal Code or special penal law that defines and punishes the act, even if it be socially or morally wrong, no criminal liability is incurred by its commission. Court decisions are not sources of criminal law because they merely explain the meaning of and apply the law as enacted by the legislative branch of the government. The power to define and punish crimes are stated in several jurisprudence. In People versus Santiago, the state has the authority under its police power to define and punish crimes and to lay down rules of criminal procedure. States, as a part of their police power, have a large measure of discretion in creating and defining criminal offense. In U.S. versus Pablo, the right of prosecution and punishment for a crime is one of the attributes that, by a natural law, belongs to the sovereign power instinctively charged by the common will of the members of society to look after, guard, and defend the interests of the community, the individual, and social rights and liberties of every citizen, and the guarantee of the exercise of his rights. The following are the limitations on the power of the lawmaking body to enact penal legislation. The Bill of Rights of the 1987 Constitution imposes the following limitations. 1. No ex post facto law or bill of attainder shall be enacted. 2. No person shall be held to answer for a criminal offense without due process of law. It should be noted that the first limitation prohibits the passage of retroactive laws which are prejudicial to the accused. An ex post facto law is the one which 1. Makes criminal an act done before the passage of the law and which was innocent when done and punishes such an act. 2. Aggravates a crime or makes it greater than it was when committed. 3. Changes the punishment and inflicts a greater punishment than the law annexed to the crime when committed. 4. Alters the legal rules of evidence and authorizes conviction upon less or different testimony than the law required at the time of the commission of the offense. 5. Assumes to regulate civil rights and remedies only, in effect imposes penalty or deprivation of a right for something which when done was lawful. And 6. Deprives a person accused of a crime some lawful protection to which he has become entitled, such as the protection of a former conviction or acquittal, or a proclamation of an amnesty. A bill of attainder is a legislative act which inflicts punishment without trial. Its essence is the substitution of a legislative act for a judicial determination of guilt, as stated in the case of People v. Ferrer, 48 SCRA 382-395. This ends the part 1 of this digital reviewer. To become updated with the new uploads, please click the subscribe button and the notification bell. See you again in our next reviewer.